at the expense of everyday Floridians, will provide pretrial immunity to the largest corporations in the state of Florida. It's disappointing because it should not be our priority at this time, but it's also disappointing because, as Representative Smith said, the bill's a little sloppy in its wording. The bill says that a defendant is going to have immunity if they make a good faith effort to substantially comply with authoritative or controlling government-issued health standards or guidance, and yet does not define standards or guidance. And it's a little interesting to me because I'm wondering if a comms intern goes on Facebook and makes a post on the behalf of a municipality, is that a standard or guidance? If a mayor makes some comments at a press conference, is that a standard or guidance? You look at the fact also that a defendant gets a menu of standards or guidance to choose from. They can pick any standard or guidance issued by any government authority in this state, and that's the one that they get to use as a defense. That's the one that they get to use to invoke this right of pretrial immunity. That's the standard. Whatever one they choose, as these attorneys are going to engage in this race to the bottom to identify the government entity that has the worst and least comprehensive standards, that's the one that they're going to choose to get immunity. And in addition to that, I have to say I'm genuinely surprised that government entities are covered in this bill. I want you to think about that. You get immunity if you make a good faith effort to substantially comply with standards or guidance issued by a government. And governments are eligible to get immunity under this bill. I imagine on the other side of the aisle there are not many people who are fans of Governor Cuomo. Governor Cuomo issued some standards and some guidance and some policies that sent COVID-positive people into nursing homes. He was following his own standard. And people got sick and died because he was following his standards. There's a circularity to this because the governor should probably be held accountable for that, and yet the very cause of action for a COVID-related tort claim would also serve as the source of his immunity against those claims. There's a circularity to this bill that's genuinely surprising because I know folks on the other side of the aisle here believe that the law should be used to restrain government and not to restrain people seeking justice when their government wrongs them. It's surprising to me, but in addition to that, I just want to say, it's been said before, that this bill is an illusory promise. The proponents of the bill and the staff analysis went out of their way to say that, no, we're not foreclosing the possibility that someone bringing a COVID-related tort claim might succeed. We're not foreclosing that possibility. We're just saying that if you're going to bring such a claim, some conditions need to be met. But when you look at the conditions, they can't really be met. The affidavit requirement, asking a doctor to do something that he can't do, to attest under penalty of perjury as to facts that he's not qualified to attest to, it's an impossibility. And so, for me, this bill has a when pigs fly sort of quality to it. You can file a COVID-related tort claim, and you have the possibility of succeeding when pigs fly, or when hell freezes over, or when doctors do things that they know they can't do. This bill should not be our priority. It shouldn't be the second bill we hear. We have constituents struggling, businesses closing, folks getting sick. We could fill the agenda with bill after bill to help those people, and yet this is the second bill we hear. It's not well crafted, and we should not vote for this bill. Thank you, Mr. Speaker.
Thank you, Representative Hardy.